Hello everyone, welcome to the YouTube channel of Civil Panda. Today we are going to discuss about basic structure. So let us begin. What is basic structure? Basic structure is a doctrine of judicial review which is invented by Supreme Court in Keshwanand Bharati case versus State of Kerala in 1973. अब आपसे कोई बेसिक स्ट्रक्चर पूछेगा तो आप ये बताते हो कि बेसिक स्ट्रक्चर इज दैट पार्ट ऑफ कॉन्स्टिट्यूशन विच पार्लियामेंट कैन नॉट अमेंड. दिस इज नॉट द राइट आंसर. If someone asks you what is basic structure, you are ought to give the following definition. Basic structure is the doctrine of judicial review which is utilized by Supreme Court or judiciary to examine the constitutional validity of the law. This doctrine was invented by judiciary in Keshwanand Bharati case versus State of Kerala in 1973. What is the context of this basic structure? Why this debate around basic structure evolved in India? It is to be noted that India adopted parliamentary form of government from Britain. Yes, we adopted parliamentary form of government from Britain. And in Britain, there is a concept of parliamentary sovereignty. What do I mean by parliamentary sovereignty? Parliamentary sovereignty means that the judiciary in Britain cannot examine the constitutional validity of the law. Parliament in Britain is supreme authority to make the law. Judiciary cannot exercise its judicial review power to the acts passed by legislature, but it can exercise that judicial review when it comes to the executive act. But there is no judicial review in Britain when it comes to the laws passed by legislature, that is parliament. Hence, in Britain, there is a concept of parliamentary sovereignty. But why this issue arises in India? The Constitution of India commenced in 1950. And in the very first decade, dispute emerges between judiciary and parliament over the amending power of parliament. It was not clear that whether, just like in Britain, in India, parliament is sovereign. Can parliament take away any fundamental right? Can parliament amend any power of the constitution? Hence, it was not clear that what is the scope of amending power of parliament. Hence, here we are going to discuss about the evolution of basic structure doctrine in Indian context. Here in Shankari Prasad case, judiciary acted in a passive manner. Why I am saying that judiciary acted in a passive manner? It was the era of Congress and the domination of Pandit Nehru over the Indian politics is well known. Judiciary avoided any kind of conflict with the parliament and executive. Hence, judiciary restrained herself and acted in a passive manner. But in 1967, Golaknath case, judiciary reversed its decision and judiciary held that parliament does not have any right to amend the constitution to take away the fundamental right. Parliament does not have power to take away the fundamental right. What does that imply? That means judiciary is limiting the amending power of parliament. Why judiciary changed its stance? In 1967, Indian politics witnessed the watershed moment. There was breakdown of Congress machinery. Hence, judiciary can act in open manner and judiciary became the activist judiciary. You can also say that Golaknath case was the first ever case to involve the concept of judicial activism. We will discuss what is judicial activism in the subsequent lectures. But what was the response of the parliament? The parliament brought 24th Amendment Act. And parliament inserted an article in the constitution and said that if any law, any constitutional amendment brought by parliament under article 368, article 13 will not apply to it. What is article 13? Article 13 says that any law inconsistent with fundamental right shall be void. But parliament brought 24th Amendment Act and it said that if I bring any amendment law under article 368 to amend the constitution, whether it is to take away the fundamental right, whether it is to destroy the basic structure or anything, I can do anything I want. I can amend any provisions of the constitution. You cannot review the act. Hence, what does that imply? That again implied that limited the judicial review power of judiciary. But in the watershed moment, the historic case of Anand Bharati versus State of Kerala in 1973, judiciary said that, okay, well, in this case, judiciary acted very smartly. Judiciary said, all right, you have all the amending power. You can amend any provision of the constitution, exercise your amending power. I will not consider amendment under Article 368 as a law under Article 13. I will not declare it void. But you cannot amend the constitution to the extent it destroys the basic structure of the constitution. Hence, in this case, judiciary given the doctrine of basic structure. Let me tell you one more interesting fact. Through the First Amendment Act, Parliament has inserted 9th schedule in Indian Constitution. 9th schedule is famously known as the black hole of Indian Constitution. Parliament said that if I place any law, whether it is passed by Union Parliament or state legislature, if I place any law in the 9th schedule, judiciary will not have the power of judicial review. But again, judiciary acted very smartly and judiciary said in the famous IR Kohlu case that yes, any law which is added in the 9th schedule, I will not review it. But any law which is inserted in the 9th schedule before 24th April 1973 will be immune from the judicial review, and any law, any act which is placed in the 9th schedule after 24th April 1973, judicial review will apply to it. Hence, here we have touched the basics of doctrine. What is basic structure? Now, I am going to discuss with you all the advantages and disadvantages of the basic structure doctrine. What is the disadvantage of basic structure doctrine? Look here. Basic structure doctrine is nowhere mentioned in the constitution. There is nowhere mentioned the list of basic structure. Who determines the list of basic structure? Judiciary determines the list of basic structure from case to case basis. It is the extreme form of judicial creativity. Judiciary has created the doctrine of basic structure. There is no such thing mentioned in the constitution. Constitution itself does not limit the amending power of the constitution. Hence, we say that judiciary is entering into the domain of the legislature. The doctrine of basic structure is like a hanging sword on the neck of parliament. That parliament, if you do anything which is irrelevant for me, I will declare it void as the violation of basic structure. It is very subjective in nature. Also to be noted that in Keshwanand Bharati case, which was 13-judge bench, yes, it was a 13-judge bench, and the doctrine of basic structure came into existence by the vote of one judge. 6 judges were against the structure. 6 judges were in favor of the basic structure. The 13th judge given its advice in the favor of jurisdiction, and hence what comes? The doctrine of basic structure in the Indian domain, just the vote of one judge. But it is a paradox. There are certain advantages of the doctrine. This doctrine has saved the India from entering into the path of other third world countries, which ultimately collapsed and democracy shattered away. But India remains a democracy until we are enjoying the fundamental rights. There was a time when executive went on to undermine the very basics of the constitution. Judiciary do not care about the separation of power, and it went on to such an extent to preserve your fundamental right that it invented the doctrine of basic structure. Hence, it is like the two-edged sword. By the end of this video, I am going to discuss with you all certain practice questions. Question number 1. What is the doctrine of basic structure? Question number 2. In which case the doctrine of basic structure invented by judiciary? Question number 3. What is the significance of doctrine of basic structure, which is a very important question. Question number 4. Discuss the evolution of doctrine of basic structure. In the evolution of doctrine of basic structure, you need to talk about the cases which I have told you. Shankari Prasad case, Golaknath case, Keshwanand Bharati case, IR Kohlu case. Hence, I hope I have touched all the basic tenets of doctrine of basic structure. And whether if there are a few things which are remaining, a few basic concepts, I will cover further in the subsequent lectures. So, keep learning, keep writing, learn with Civil Panda.